So here's the question, Cplr 2217, which of the following statements are true? And the answer is A. So let's get that out of the way. The answer is A, even though it says the word any. And typically, whenever you see the word any, you have to be really, really sure before you pick that. So it's similar to when you see always or never. Those kind of things, you got to be really sure before you pick it. But in this case, it is accurate. It says right out of the book, any motion may be referred. So the reason B is wrong is because it says may be accompanied by an affidavit. And in fact, it's a shall. It must or it shall be accompanied by an affidavit, specifying the new facts, if there be any, and more importantly, it has to say the result of any prior motion. So if you've made the same motion 35 times, you're going to have to say, I've made this motion 35 times, and this is what happens on each of those occasions. C is wrong because it can also be transferred to another judge on court order, not just stipulation of parties who have appeared. So if a judge is unable to hear it, there could be a court order that moves it to another judge, or there could be stipulation of all parties to move it to another judge. So D and E are basically the same, it's coming out of the same question. What happens when a judge gets a motion and there's already a pending motion in the same action that another judge is deciding? And this case has already been this is the case actually was decided by appellate courts that said the judge is not required to refer it to another judge. So I actually used the example from that case law, which was a motion for preliminary injunction while there was a pending motion for summary judgment, and the appellate court ruled that there was no requirement that the judge refer it. So both of those are false.